Yes, this is a really good precedent. For those of us who are feeling a little fried tonight and maybe don't want to Google it, this is a Supreme Court adjudicated case from 1990 that involved a retired government employee named James Richmond. He was advised by OPM, the Office of Personnel Management, the same entity that is extending these deferred resignation packages to all federal employees right now, that he would be eligible for certain retirement benefits once he did retire. And that was incorrect. And so he unknowingly violated certain income limits and became ineligible for the benefits. He found this very upsetting, obviously, and decided to sue OPM to get the benefits back. His case relied on the idea of equitable estoppel, which is essentially that he was misled by an official government employee, and so they can't renege on something they said, even if they misrepresented the facts. However, the Supreme Court sided against Richmond and for the federal government, saying that only Congress has the power of the purse, and that if this was not something that was officially authorized by Congress, that it was ineligible, that he was ineligible for these benefits. And so this set a precedent that applies to these buyout or deferred resignation packages, because even though the memo released this morning states that this is legal and does not require congressional approval, it just states that. Importantly, this also established a precedent where governmental employees and agencies cannot even be held liable for giving you misrepresented information unless Congress expressly provides a remedy. So this is why these deferred resignation layoff packages are incredibly dodgy right now, and why no one should be, relying on the memo that went out this morning. And you can see my previous video for additionally why you might not want to trust this particular attorney in particular. There are some other precedents and laws that these packages might run afoul of, including the Comptroller General decision from 1971, which stated that you must perform duties in order to receive pay. You cannot pay federal employees solely to remain employed. So if they're offering to pay folks for 7 months and are not saying that they have to actually perform their duties, if it even appears like they're just paying people to remain employed, then that could run afoul of that decision. There are also federal employee ethics rules that would run afoul of the stipulation in the memo that the federal employees accepting this deferred resignation package could go ahead and find another job and could work that job as a dual situation while they were working out their remaining 7 months. This could very easily be seen as a misappropriation of public funds. There are a lot of different rules and laws that this would run up against. So this is one of those case by case basis things. So you could easily end up in a really bad situation if you actually chose to invoke that clause of the memo that was sent out. So based on even just these things that we're talking about here, likely these packages do in fact violate congressional appropriations, not to mention several other issues. I am not a lawyer. This is not legal advice. It's just one of those things that, like, if you're being offered something like this, doing your due diligence on, legal precedent, ethics laws, rules, etc., for your specific department, for your specific job is also really important, because just going by whatever this memo says, even if there's a letterhead on it, I mean, y'all know better than I do, it's just not going to cut it. So please, really, really think about it hard if you are considering taking this offer.